Hi friends from around the world. This is about enforcement in trademark rights. So enforcement, I talked about enforcement in previous videos, but rather from the focus of administrative enforcement or civil enforcement in the courts, not of criminal enforcement, because only the big businesses do investigation and put them at the disposal of the law enforcement agencies, and then it becomes a criminal investigation by them. Small businesses, they would not do that kind of investigation and will not grow into this kind of criminal enforcement. But now this is different here in level 3 for lawyers. You might well become involved in criminal enforcement where it is IP goods involved, right? And it is more about, not about murder, that's not about assassination or so. It is about interpretation of EU law, and more often than not it is a kind of a civil law approach rather than a typical criminal defense attorney's work. This is a case from Finland. So in Finland there was a individual guy, who received from China 150 ball bearings. What is ball bearings? Rodamientos de bolas, or roulements à Bille, or Kugellager in German. So here on the screen you have it. These are kind of for spare parts, so to say, for heavy industry. So that was 150 ball bearings and 710 kilos, what was the weight of the shipment. So he received this from China. And after customs clearance, the individual in Finland, they stored it at home, so to say. After a certain moment, after 3 years, part of the shipment was sent to a third party who then sent it to Russia. So that is on the fact side. There's nothing else. And the case is about, the bearings, they had a trademark. They had a trademark which was INA and which was not authorized by the trademark owner. So the ball bearings, they were infringing goods on the original trademark INA. Now the question was, what has been transposed Article 5 of the Trademark Directive. Here you have it on the screen. There's a requirement of use in trade, right? Use in trade, and you need to have it used in trade, and this has been transposed into the Finnish law. Now the Finnish law enforcement, they made some investigations and they brought the case to the court against Bille. Although he was in the first instance acquitted with regard to criminal charges, he was, so to say, condemned to pay damages for the trademark owner. And I think it was probably the trademark owner who initiated all the investigations from the law enforcement. Now, the Bille was not content with that. It went up and up, and it ended at the Supreme Court in Finland, who then, we know that they make a preliminary questions. They referred to the European Court of Justice, and this on the interpretation of use in trade, Article 5 Trademark Directive. So here we are. The decision as such, I would say, departs a bit from what we have seen so far in the L'Oreal case. Here we have the reference where a trademark owner well, not a trademark owner, the infringer himself must have to do, or must do the trade, so to say. And here we have a third party. We have somebody, an individual from outside, who is a kind of intermediary and has no real dealing with the case, but just acts on instructions from another party, the real infringer, so to say. So what are the questions here which the Court of Justice has addressed with regard to the enforcement questions which have been addressed to him by the Finnish Supreme Court? The first was it was not a private use. So if it is a private use, then it would not be use and trade. A private use, so for your own sake only, I would say. So in that case, 710 kilos, 150 ball bearings. So that is, and this is for the industry, and so this is obviously not for private use. So this can be excluded. It has a trade connotations. It has something which has to go out to another party and is not consumed by the person. So that is the first issue. But it said, the Court of Justice, they said, well, the final word on this has to be said or ruled by the recognizing court, the Supreme Court, or the inferior courts in Finland. So it is just a remark, so to say, what would be European and common sense in assessment from the European Court of Justice. So the second is what is about the importing of goods. That guy from Finland, it provided its address, and it provided its name. And it didn't went much further. It probably had some contact with the customs clearance in order to get this delivered to his house, and then afterwards it released some of the goods to a third party. So that was all he was doing. So this is, according to the Court of Justice, a activity which falls in the use of trade, even if it is not the person who itself decides what to do with a shipment. So this is a departure, I would say, from what we have seen so far. It is a kind of trend in order to limit the freedom or the possibilities of the trademark infringers, and that is a general tendency. We have seen this with regard to the Court of Justice. If it is good or bad, I will not enter into it. I'm not defending at least the infringing industry. That is not my bearing here, but it depends, and it goes a bit in the sense, although, well, trade, is he in the trade? He is part of the trade, yeah. So maybe he is part of the link of the trade, although here the real infringer is a bit hiding behind the curtain. So use of the sign, acting for a third party, not for himself, that would be not harm the use of the sign. So he still would be the person, also the person, so the infringing person, so the one behind the curtain. He is deciding on the issues with even more reason, but that one will not escape that he is also using the goods with the sign in the trade, right? Now the last and anecdotal, I would say, is, and I think that was the initial thinking of the Finnish court, the remuneration the guy in Finland, he received was not in money. He didn't receive any money. He received a case of cigars or cigarettes and a bottle of cognac. That's all what he get out of the deal. So the Finnish court might have in mind, well, this is not really trade, right? I would do it for a real benefit if I enter into such kind of risk that would need some kind of serious compensation in order to engage in that kind of activity. And well, this was part of the question being put, the main question, I think, being put to the European Court of Justice. And the Court of Justice, they said clearly, well, remuneration is not part of it. It's not necessary requirement for use in trade. So that is an important issue to take into account, that we extend the responsibility for infringement not only to the party in itself who decides to import, who is behind the curtain, who is doing the things, but the risk now is also on all associates, or all people who are acting on the different steps within the trade, even if they don't get money out of it, even if they don't get money out of it. That seems to be a quite interesting development here made by the Court of Justice. So this is a case which is very short. So you may go into and read it. It's only 1.5 pages or so, but I think it gives you a clear idea of a shifting of tendency, limiting the possibilities of the infringers, and giving law enforcement and criminal enforcement, so to say, a bit more power in order to be more effective and having more tools against the infringing industry. Thank you for this one, and well, I encourage you to have a look at the judgment.